In this presentation, I will talk about the utilization of examination results of other intellectual property offices. The main purpose of this presentation is to understand the background and structure of work sharing among intellectual property offices and how to find, read, and use the ISRs, WOISAs, and IPERs. There are 4 parts in this presentation. First, I will explain about the background of work sharing. Next, I will talk about the patent family. Then, I will move on to the next topic, deriving and utilizing external patent office results. Finally, I will discuss about interpreting and utilizing ISRs, WOISAs, and IPERs. First, I will explain about the background of work sharing in the following slides. The bar graph on the left shows a change in the number of patent applications filed in the world from 2003 to 2012. Bars in a red color represents overseas patent applications, and bars with blue color represents domestic patent applications. Let's focus on the overseas patent applications. As you can see, the number of overseas patent applications has been increasing over years. This is a result of a growth of global operations of international companies. Because of this rapid increase of overseas applications, it becomes quite common that the same invention is examined at multiple patent offices, which is not efficient from the worldwide point of view. In order to reduce the redundant workload for examining the same invention, a demand for work sharing has been growing, and the work sharing system among patent offices has been developed over years. In order to prevent this work redundancy, a work sharing system was introduced. With work sharing, information such as prior art search, references, office action documents, and amendment documents are shared among patent offices, and other examiners can utilize the information before their own research and examination if it is available. By doing so, work redundancy can be eliminated, as well as the efficiency of examination would be improved, and the discrepancy in examination results will be reduced among the offices. Therefore, work sharing is important for examiners as well as applicants, because applicants would expect more harmonized office actions from all the patent offices worldwide, which eventually resulted the patent right more stable. This diagram illustrates the dossier access system. It is currently in operation as a tool contributing to work sharing internationally. The dossier access system is a system that provides examiners in each office with examination-related information such as exam results, references, office and applicant action documents. In the One Portal Dossier, or OPD in short, is made by mutual cooperation among the IP5 offices, the IPO, the JPO, KIPO, CNIPA, and the USPTO, for the elimination of unnecessary duplication of work among the offices, enhancement of patent examination efficiency and quality, and guarantee the stability of patent right. Examination-related information is mutually provided in English among the IP5 offices, each of which creates its own user interface. Each IP5 office has the support system to provide the domestic dossier information and the legal status of applications examined by each office. The JPO provides a system called the Advanced Industrial Property Network, or AIPN, which is the use of examiners of foreign intellectual property offices. AIPN provides the examination-related information in English using machine translation in order to reduce workload in foreign IPOs. Shown as in this picture, each IP5 office provides a corresponding system to complete the one portal dossier. Next, I will talk about a patent family. What's patent family anyway? This chart shows a typical example of a patent family. When patent applications based on the same invention is filed to 2 or more countries based on the Paris Convention for Protection of Industrial Property, these patent applications form a patent family. In other words, a patent family is the same invention disclosed by a common inventors and applied with more than one application. As you can easily imagine, examiners' workload in each country to examine each of applications in a patent family will be greatly reduced by the work sharing that I explained in the previous slides. There are 2 types of patent family. I will explain about these 2 types of patent family in the next slides. The first type is an international patent family. As shown in this picture, application filed in a country A first can be filed in a country B later by claiming priority under Paris Convention or by filing based on the Patent Cooperation Treaty or PCT. The second type is called domestic family, which consists of any national patent applications having at least one priority in common by using internal priority and or divisional application. As this picture shows, by claiming the internal priority in a country A, applicant can file other applications with the same invention and improved inventions within the same country A during a certain period after the filing of the first invention. In most of the countries, it is 18 months after the filing date of the first application. To summarize, there are 2 types of the patent family. One is international and the other is domestic. As shown in the past slide, the patent family can include both international and domestic families. When the examinations of any application in the patent family begins, the examination workload of other patent family examinations could be greatly reduced by referring the ongoing or past patent family examinations. As I explained in the background part, by using the one portal dossier, you can refer the international patent family examinations of other IPOs. This is how the international work sharing works. Let's move on to the next topic, retrieving and utilizing the external patent office results. Here I will show you how you can find the external patent office examination related documents, which is belonging to the same patent family. As I explained in the first part of this presentation, IP5 offices have the system to share the domestic dossier information and the legal status of applications examined by each office through Internet for other IP offices all over the world. From the list shown below, I will explain 2 of these share systems, JPO's AIPN and WIPO's patent scope. USPTO's US pair and EP's European Patent Register, also known as ESPASnet, are also a part of the Patent Information Share System. First, I would like to introduce JPO's AIPN, the Advanced IP Network. The AIPN is the web-based service only for examiners in the foreign IP offices, and it is not a service for the public. The AIPN provides legal status of published applications and dossier information. The dossier information is available if the examination is ongoing or it has done. Other information, such as a notification of reasons of refusal, cited documents, amendments, and written opinions from applicants, are also available. You may wonder if the old documents are written in Japanese and you couldn't read. Don't worry, AIPN provides almost all Japanese dossier information in English through machine translation. The AIPN is a useful tool for utilizing the examination and search results conducted by the JPO and contributes to the work sharing among IP offices. It also helps applicants to acquire the IP rights smoothly. The AIPN started service on 12th October 2004, and it's being used by 69 international property organizations all over the world. The members of AIPN are shown here. The AIPN provides three services. First, dossier information including specification of application, office actions, and other prosecution documents. Second, the current legal status of the application and the prosecution history. Third, cited documents, patent family information. How often is the data stored in AIPN updated? The frequency of AIPN data updates depends on the types of information. The file wrapper information will be available after the publication or registration of the application. Legal status and cited documents will be available within 1 month at the latest after the publication or the registration of the application. Information of patent family are updated at any time. Lastly, as an overview of AIPN, I would like to explain how to use AIPN briefly. This is the interface of AIPN top page. You can search the dossier information of the IP5 applications and its patent family through its application number or patent number. As I explained, AIPN provides the English translation of dossier and patent family information for your convenience. You also can utilize the IPC, FI, or FTAM information, as well as the citation information, which may be quite useful when you conduct a prior art search. Next, I will discuss about patent scope. Patent scope is provided by the WIPO, which is an official publication platform of the PCT system. Through patent scope, you can inspect patent documents, information of each international phase, such as ISRs, WOs, IPRP, and priority documents, international legal status, and national phase entry data. In the following pages, I would like to explain how to inspect files in the international phase using patent scope. This is the top page of patent scope. Let's push the button below saying Access the patent scope database. Then you will see the page shown on the left, the simple search page. Select front page, enter WO 2008 123456 in the box and click search button. Search result list will appear then. There is only one document in the list because we specify the publication number. Now click on the publication number to inspect the international phase information. Now you have an access to the information such as bibliographic data and documents of international phase, as well as full text and drawings. This is a bibliographic data, and you can check IPC, CPC, when it was filed, when it was published, and so on. By clicking the Documents tab, you can also investigate and download the ISRs, WOISAs, etc. This is the downloaded sample of the ISR and the WOISA. How to read and use the ISA and WOISA. In the following slides, I will explain how to interpret and utilize the ISR, WOISAs, and IPERs. There are 3 items in this section. In part A, I will briefly show you what are the ISR, WOISA, and IPER. In part B, the details of the International Search Report, or ISR, will be discussed. Lastly, in part C, I will talk about the contents of the written opinion of the International Searching Authority, WOISA. In part D, Internal Preliminary Examination Report, or IPER, will be briefly discussed. What are the ISR, the WOISA, and IPER? In this page, I will explain about the difference among 3 kinds of report made by international authority: ISR, WOISA, and IPER. ISR and WOISA are prepared by ISA, and IPER is prepared by IPEA. Before going to details of each report, I'd like to show you outlines which are picked out from PCT guidelines. The PCT guidelines give instructions for international authorities during the international search and examination procedures. Now, what is International Search Report, or ISR in short? The guidelines indicate that ISR includes prior art documents discovered through the international search. The ISR is made available publicly, and ISR provides reference information for the examiner in each designated office. What I would like to emphasize here is that the ISR is mere reference information for us, and our domestic phase examination is not bounded by the contents of ISR. The ISR is rather beneficial information for us because an examiner had searched prior arts before making the ISR. We are responsible to make good use of ISR. Based on the ISR, the same examiner wrote the WOISA. It identifies whether or not the claimed invention of the application is novel, involves an inventive step, and is industrially applicable. The examiner also can express the opinion regarding the unity and clarity of the claims in the WOISA. Thus, the WOISA helps us to understand the examiner's opinion concerning patentability and why. Again, I would like to emphasize that the examiner's opinion is not enforced in the domestic phase. You have a freedom to choose if you follow the examiner's opinion or not. Assuming that international preliminary examination is demanded, an IPER could be created at the end of the process of examination, taking into account amendments or observations that the applicant has made during this process. In other words, if there is no reaction from the applicants to the ISR and the WOISA, IPER would not be made. Since the format of IPER is quite similar to ISA and WOISA, I will explain about IPER only briefly in this presentation. Let me show you a flowchart of an international application and explain about the workflow briefly. When the international application is applied, International Searching Authority, which could be a designated IPO office or a WIPO, make a ISR and WOISA. If the result of the ISR is negative, which means the claimed invention would not be patentable, the applicant has a choice. The choices are: he or she obeys the examiner's opinion and let the national phase begin, or amends the claim and asks for examination again. If the applicants decide to amend the claim, the applicant can file a demand for international preliminary examination and submit an amendment or argument against ISA examiner's opinion. Then, IPER examiner makes a report, which is IPER, to show his or her judgment on patentability, taking amendments or observations into account that the applicant has made during its process. That's the end of the international phase, and then application shifts to the national phase. Therefore, in the international phase, only ISA, WOISA, and IPER are made for one application. Next, I will discuss about the details of the International Search Report. This is taken from the front page of the ISR, International Search Report. The upper part of the front page displays the basic information related to the international application, such as application number, filing date, and applicant's name. The first item of the ISR is the basis of the report. We can see from these checkboxes in the language on which the ISA based, meaning whether the international search was carried out based on the originally filed application language or the translation language of the application. In this example, the ISR is made on the basis of the international application itself. The front page also indicates whether or not ISR includes checkboxes for item number 2 and item number 3. Item number 2 provides that international application includes some claims that cannot be searched. Item number 3 indicates if the claims lack of unity of invention. In what situation are boxes number 2 or 3 checked? In the next slides, I will show you when they are checked. In the PCT, there are 3 types of claims which are not required to search. The first type is the claim described in the application is categorized as one of the following: scientific and mathematical theories, plant and animal varieties, or essentially biology process for the production of plants and animals, schemes, rule of methods of doing business, etc. The JPO had not been required to search surgery and diagnostic methods for treatment of the human or animal body. However, JPO started to make the ISR for inventions of this particular category several years ago in order to harmonize with other IP offices. Second type is that the description, the claims or drawings are so unclear, or the claims are so inadequately supported by the description that no meaningful search can be carried out. Third type is a multiple dependent claim which refers to more than one other claims. Some IP offices consider it is improper if a multiple dependent claim referring to any other multiple dependent claims, and they do not require to search such claims. The JPO allows such claims though. In the figure shown below, both claims 3 and 4 refer claims 1 and 2, and so they are categorized as multiple dependent claims. Claims 5 and 6 refer the multiple dependent claims 3 and 4, and so there are 2 claims may be excluded from the prior art search. In any case described here, the box number 2 will be checked. The box number 2, which indicates the observation where certain claims are found unresearchable, consists of 3 items. Item 1 in the blue box is corresponding to the first type in the previous slide, indicating that claims related to a subject matter in which ISR is not required to search. In this example, the International Searching Authority ISA removed Claim 8 from international search because the subject matter of Claim 8 relates to a method of doing business. As shown in the previous slide, to a method of doing business is not required to search. Item 2 in the red box is corresponding to the second type, showing that the description, claims, and the drawing fail to comply with the prescribed requirements. Item 3 in the green box is corresponding to the third type, if there is a multiple claim referring multiple dependent claims. As I explained in the previous slide, the JPO allows this type of claims and does not use this box. There is another case in which the ISA is not required to carry out such, which is called lack of unity of invention. An international application shall relate to one invention only or to a group of inventions linking each other to form a single general inventive concept. This is to assure the fairness among applicants. If some applicants pay application fee just for one invention, whereas others pay the same application fee for multiple inventions, it is obviously unfair. If the ISA considers that the international application does not comply with the requirement of unity of invention, it shall invite the applicant to pay additional fees. According to circumstances, the ISA searches only a part of claims consisting a single invention or claims with multiple inventions if the applicant agrees to pay additional fee. In the example shown here, the application includes 3 independent claims. Both Claim 1 and Claim 2 have Step A in common as a special technical feature, and so they do not lack the unity of invention. However, Claim 1 and Claim 3 only shares the Step B, not the Step A. Unless the Step A and B form a single inventive concept, 2 inventions are included in these claims. One invention represented by Claim 2 and another invention represented by Claim 3. Therefore, Claim 3 lacks the unity of invention. When the ISA decides that the international application does not comply with the requirement of unity of invention, the ISA asks the applicants to pay additional fees. I will explain how it goes in the next slide. This is a workflow when the ISA decides that the international application does not comply with the requirement of unity of invention. First, ISA informs the applicant if the lack of unity of invention by a communication. It contains an invention to pay additional fees. The applicant has 3 options: no reaction, paying additional fees, or protesting the allegation of lack of unity of invention on paying additional fees. Depending on the applicant's reaction, the ISA does the following. If the applicant did nothing, the ISA conducts prior art search and makes the ISR for the first invention only. If applicant pays additional fees, the ISA searches groups of invention for which the search fee and additional fees were paid. If applicant protests along with paying, the ISA searches all of the inventions and examines the protest. To the extent that the applicant's protest is found to be justified, additional fee is reimbursed. The important prior point for the examiner is not the applicant's decision about paying additional fees, but how the ISA decides which claims to be searched based on the decision regarding lack of unity of invention. In box number 3, we see the ISA's decision about the unity of invention, applicant's reaction, and the remark on protest accompanying the additional search fee payment. At the top of the box number 3, the ISA decisions are written with explanation. In this example, application includes 2 inventions. Because the subject matter of Claim 1 is not novel and involves no special technical features with respect to Document 1, and technical features of Claim 2 and Claim 16 does not form a single general inventive concept. In the middle of the box, applicant's reaction is indicated. In this case, the applicant paid or required additional fees. Remark on protest section at the bottom shows that the applicant had protested the allegation of lack of unity of invention. As I described here, the information about lack of unity of invention is available in the box number 3. Next page describes the result of international search, a main body of the ISR. In box A, the ISA indicates the International Patent Classification (IPC) symbols corresponding to the subject matter of a claimed invention. In box B, the technical fields which are searched by ISA examiner is identified by IPCs. The classification indicated in box B does not necessarily match with the classification showed in box A, because more general and broader technical fields than the technical field of the application itself are searched in general. In this example, we see that the ISA searched G06Q10-00 in addition to G06Q50-00. When documentations other than the PCT minimum documentation is searched, the searched documentations are identified in box B. In this example, we see that the ISA has searched Japanese utility model collection in addition to the PCT minimum documentation. When electronic databases such as Google or IEEE Explorer are used for the international search, the name of the database may be included in the search reports too. We are now approaching the most important part of the ISR. Box C informs documents considered to be relevant on the basis of the international search. There are 3 parts in box C: citation category, citation of document together with identification of relevant passages, and identification of relevant claim numbers. Identification of any document is made according to WIPO standards SD14. When the cited document is a member of patent family, family numbers and relevant passages are also shown along with the cited document, preceded by the ampersand sign. Instead of using ampersand sign to show the patent family numbers, some IPAs, including the JPO, recommends to use the patent family annex, which follows the box C. The example will be shown in the next slide. By showing the patent family members along with the cited document, we can select the citation in the most convenient language to read. However, I would also notify you that the contents of documents in the same family may be different. If you cannot find the relevant passages in the document with the most convenient language, you may consider to read the originally cited document with the machine translation. So far, I just explained about the column in the center. Let's continue to discuss about the left column in the next slide. As I mentioned, a separate sheet may be used to show the patent family. As shown here, the relationship between the cited documents and their patent family is clearly shown. If the patent family annex is used, relevant passages may be also indicated in this patent family annex list. Left side column shows the citation categories given for the cited documents by alphabets such as X, Y, and A. The explanation of each citation category is displayed in the lower part of the original document, which is shown in the green box here. A citation category should always be indicated for each cited document. There are a lot of citation categories. I would like to mention important categories which are commonly used. When a document cited in the ISR is particularly relevant to the claimed invention, it is indicated by the letters either X or Y. If, when taking the document alone, a cited documentation cannot be considered novel or to involve an inventive step, category X is given. If the claimed invention cannot be considered to involve an inventive step, when the document is combined with the one or more other documents in the same category, and such combination is obvious to a person skilled in the art, the document is categorized as Y. Category A means that the document cited in the ISRs represents state of the art, not relevant to the novelty or inventive step of the claimed invention. Therefore, the relevance between the claimed invention and the documents categorized X is the highest. Documents with category Y follows, and the documents with category A is not considered as closely relevant. Now, what's the relationship between the left column and the right column in the box C? Each citation includes a reference to the claims, shown in the right column with the green box here. As you can see, it is possible for the same document to represent different citation categories with respect to different claims. Each line shows the relationship between the category and the relevant claims number. In this example, the first cited document discloses the subject matter to deny novelty and or inventive step of claims 1 to 7. It denies the inventive step of claims 9 through 13 when combined with another document cited in the ISR, and it represents the general state of the art, which is not considered to be of particular relevance for the subject matter of claims 14 through 20. What about the second cited document? You can see that it is Y category and relevant to claims 9 through 13. Thus, the International Search Report shows that claims 9 through 13 are considered not to involve inventive step when the first and second cited documents are combined. The first and second cited documents are categorized A for claims 14 through 20, indicating that the claims 14 through 20 involve both novelty and inventive step. Next, I will talk about written opinion of the International Searching Authority, or WOISA. Similar to the ISR, the head of front page displays the basic information such as the international application number, filing date, and the name of the applicant. Below the basic information, There are checkboxes number 1 through number 8 in the center of the front page, which indicate the items contained in the opinion. Now let's look at the contents of each box one by one. Box number 1 is basis of the written opinion, language and other basic information, the same as ISR. In this example, the WOISA is established on the basis of the language in which the international application was filed. The box number 2 is used when the international application claims priority and the ISA has an opinion concerning validity of the priority claim. Upper checkbox is checked when the ISA did not consider the validity because the applicant has not provided the document in which the priority has been declared. In this case, the examiner makes the WOISA as if the priority is validly claimed. If the lower checkbox is checked, the ISA finds the priority claim is invalid. In this case, the opinion is made according to the international filing date as the relevant date to judge novelty. If there is no concern about the validity of the priority claim, none of the checkbox is checked. Box number 3 is used when certain claims are found unresearchable. Basically, this box corresponds to the box number 2 of ISR. In this example, claim 8 is found unresearchable because it relates to a method of doing business, which ISA do not need to make ISR and written opinion. The first two checkboxes indicate which claims are excluded from the ISR and WOISA. The following spaces are provided for specific reasons. The area in the blue box indicates that the claim relates to subject matter in which ISA is not required to search. In this example, because the subject matter of Claim 8 is a method of doing business, which is the subject matter which do not require an international search, the reason is written in the blue box area. The red box area is provided for showing that the description, claims, and drawing fail to comply with the prescribed requirements. Box number 4 is related to unity of invention, corresponding to box number 3 of ISR. We can find examiner's decision, applicant's reaction, and for which claims this opinion has been established. At the top part of the box, applicant's reaction is indicated in item 1. In this example, the applicant paid all required additional fees. Examiner's decisions are written in the middle of this box in the item 3. In this example, application includes 2 inventions. At the bottom of the box, the item number 4 indicates the examiner's decision for which claims this opinion has been established. In this example, the examiner made the written opinion in respect of claims 1 through 7 and 9 through 20. Remember, the consideration of non-establishment of opinion, box number 3, precedes the consideration of lack of unity, box number 4. Therefore, claim 8 is excluded because of the reason stated in the box number 3. Box number 5 is the most important part of WOISA. ISA examiner writes reasoned statements as to whether the claims appear to satisfy the criteria of novelty, inventive step, or non-obviousness, and industrial applicability. In this example, the examiner decided that claims number 1 through 7 is not novel and do not involve an inventive step. Claim number 9 through 13 is novel but do not involve an inventive step. Claim number 14 through 20 is novel and involves an inventive step. All of these claims found to include industrial applicability. In the item 1, the examiner's decision is simply stated by just indicating claim numbers so that no one misunderstands the decision. Item 2 of box number 5 indicates the citations, explanations concerning the opinion on novelty and inventive step. In citations, indication of any documentation is made according to WIPO standards ST14, just like the cited documentations in the ISR. Explanations follow the citations. Explanations should clearly indicate, with reference to the cited documents, the reason supporting the conclusions regarding novelty or inventive step is satisfied or not satisfied. If the examiner finds there exist some defects in the form or contents of the international application, the examiner includes this opinion in box number 7. If the ISA examiner finds any objection about the clarity of the claims, the description and the drawings, or question whether the claims are fully supported by the description, the examiner includes these observations in the written opinion using box number 8. Finally, I'll talk about the International Preliminary Examination Report, IPER, briefly. As I explained in the previous slides, the IPER is made only when the applicant made some amendments. Therefore, I explain where such information is indicated in the IPER only, because the format of other parts are just the same as the ISR and WOISA. These are cover sheet and sheet for the box number 1. This part of the cover sheet shows what are included in the report. It says, this report consists of a total of 5 sheets including this cover sheet, and this report is also accompanied by annexes comprising a total of 8 sheets, including sheets of the description, claims, and/or drawings which have been amended. In this part, you can see the included contents. Box number 2 through box number 8 are just the same as written opinion of the ISA. Box number 1 indicates that the basis of the report is different from WOISA. The item number 2 includes indications of elements of the international application which this report based on. In this case, the description includes page 1 to 65, and they are just as originally filed. That is, no amendment made to the description. Regarding the claims, the report is based on the claims 1, 3 to 18, which has received on March 16, 2013. These claims are amended from the original. The item number 3 indicates the cancelled claim by the amendment. In this case, the claim number 2 is cancelled by the amendment. To summarize, we've talked about the utilization of examination results of other intellectual property officers. I talked about the background of work sharing, then the concept of patent family. I introduced about the AIPN and patent scope and how to retrieve the information from them. Finally, I explained how to interpret and utilize the ISRs, WOISAs, and IPERs. Thank you for your attention.